Good afternoon. My name is Alena Shautsova. I am an immigration attorney from Brooklyn, New York. In today's video, I would like to talk to you again about public charge and declaration of self-sufficiency. Why? It's because it's a very, very important topic. Basically, with the declaration of self-sufficiency and new public charge rule, the landscape of adjustment of status for family members has been changed. Hopefully not forever, but has been changed significantly. It increased the workload of attorneys perhaps by 50%, and of course it increased the difficulty at which one may now become a permanent resident in the United States based on a family member's petition significantly. So what's going on? Today I would like to talk to you about factors that the government stated are going to be heavily weighted factors against one's becoming a permanent resident in the United States. So what are those factors? What are the things the government is going to look at to determine that even after you met all the other requirements, you have a legal entry, your relative submitted an affidavit of support for you, you do not have any criminal convictions, any other issues that were traditional issues for adjustment of status, like order of deportation perhaps. What are the factors that the government is going to look at to say, you know what, we do not believe you should be becoming permanent resident in the United States. And we're talking about sponsorship for your children, for your spouses, and for the parents. So what are the factors? So here is a list of negative factors that the government said are heavily weighted against finding of one's eligibility to adjust status. These factors are lack of employability, diagnosis of a significant medical condition and a lack of private health insurance, receipt of public benefits, and the person was previously found inadmissible or deportable based on a public charge ground in removal proceedings. So let's talk about each fact. Let's talk a little bit more about each factor. Lack of employability. Basically, they're going to be looking at your employment history and see if you were employed within the past 5 years. What is it that you were doing? How much money is it that you were making? Perhaps they will be asking that question. But they basically state that if you are able to work, but you do not work, it means that you lack self-sufficiency. And then they make a little bit of explanation saying that it's not the end of the story. Perhaps if your relative who's sponsoring you has sufficient assets, then we will reconsider our finding. Okay, so what's going on here? Basically, let's say a husband and a wife, traditional family, so-called, and wife has never been working, right? Or maybe husband has never been working. Maybe, traditional is not really defined as traditional. So let's say in a spousal unit, one person has not been working. Will the U.S. citizen, let's say, who has been working, be able to sponsor the spouse who's never been working? Well, apparently, yes. If a household member's income and assets overcome negative factors and resources, and the person's resources, meaning that the person who's never been employed still has to show that they have assets or they have somebody reliable to rely on. Okay? One of the factors that they're taking into consideration is the person's education and studies here. They say that unemployment will weigh heavily only if a person has not been a student, all right? And if a person is a full-time student, their lack of employment is not going to be counted against them. Here is a trick. What is a full-time student? The policy manual explains what is going to be considered a full-time student. Generally speaking, they're using a classical explanation of a full-time student as a 12 credit academical program that is going to give you some sort of a degree, associate, bachelor's, doctorate, postdoctorate, master's degree. What about English language courses? What about online studies? They stated that online studies, they will count, but I believe only 3 credits towards the threshold. And for language classes, language course of study, they will require 18 credits, that the student is enrolled in 18 credits, and online education for a language student will not be counted at all. If the alien is a language student or a vocational student, no online or distance education classes may be considered to count towards a student full course of study requirement. All right. It means that a student has to be a student, somebody who does go to classes physically. Otherwise, it doesn't count. All right. So that's where we stand with employment. As you may guess, people with off the books employment here may have real problem. We're moving on. Receipt of public benefits. That's self-explanatory by itself. Receipt of public benefits, basically, they will be counting all public benefits that will be received from February 24, 2020 onward. They do not count public benefits that became new public benefits that are going to create a problem, that were applied for, received, found to be eligible, and things like that prior to February 24, 2020. But there is a group of public benefits, let's say SSI, for example, that were a problem for the public charge inadmissibility even before this rule. They will consider those public benefits, receipt of those public benefits prior to February 24, 2020, but it will not be a heavy factor. Okay? So again, there is a complication with the public benefits. So basically, stay away from public benefits and you will not have a problem with this rule. Stay away from them from February 24th, 2020. Now, diagnosis of significant medical condition and lack of private health insurance. What basically they're saying is that they're going to be looking at the medical exam form that you will be submitting. And of course, you will have to disclose this information as well. But they will be looking at the form that you will be submitting together with your application for adjustment of status. And if they see that there is a certain diagnosis that will require extensive medical treatment, it will be a heavily negative factor against you. Plus, of course, it will be a factor only if you cannot show that you're going to have a private health insurance. I have a big issue with this rule just because it basically presumes that it will be hard for you. They do not want you to have here if you're sick. But the thing is this, from what I know, from little experience that I have personally and through my clients with the private insurance, you only can get once you are a permanent resident. All right, so that's the biggest issue here. So if basically somebody who overstayed their visa in the United States and now they're eligible for adjustment of status because their immediate relative, like a spouse or a child who is over 21, became a citizen, now they can sponsor them. But this person never had insurance and cannot get one, but is diagnosed with the serious medical issue. This person probably will not be able to adjust. Okay, they will not give you a green card, it seems. Why? It's because usually, unless it's a spouse, it's hard to show that the person, like let's say parent, will be covered by your health plan in the future once they became permanent residents. So this rule is brutal in my view. And the fourth factor is previously found inadmissible or deportable based on public charge ground in removal proceedings. You don't have to be found, you don't have to be ordered removed based on a public charge. I've seen these charges previously in early 2002. Like I've seen clients denied, they had denied cases because of the public charge rule. So what that's basically saying, that if it happened to you previously by the immigration judge or Board of Immigration Appeals, now we're going to hold it against you. They say that you can overcome this charge, but I would say that it's going to be, again, complicated. They do say that, you know, they will consider your history and your household size now. But basically what's going on is this: when somebody is placed in removal proceedings, there are allegations against the person. This is just a list of what the government put together and stated that we want you to be deported, we want you to remove you. And very often the person is going to be sustained as removable, not on all of the charges, but on some of them. But what happens is that during the master court hearing, during the first hearing, the person, through their lawyer usually, the person has to admit or deny the charges. And very often what happens is that the person may admit the charges, knowing that he may have a chance of winning on some of them, all right? So what they're saying now is that if you ever admitted to those charges, even though you were not deported based on public ground, the order does not say that they're deporting you because of the public ground, a public charge ground of inadmissibility or removability, they're going to hold it against you. How it will be relevant at all, because usually if somebody who's been previously ordered deported, that person cannot adjust their status in the United States at all, right? But I guess there are scenarios, if you did serve your time outside of the United States and then came back on a visa, that old of deportation that you had may still be used against you. I guess that's the scenario. And there is an example there that alien originally entered on a non-immigrant visa as a temporary visitor for pleasure and remained in the United States beyond the time, then was served with a notice to appear. The record shows that the immigration judge sustained all of the charges in the notice to appear, including deportability on the public charge ground. Then the person lived in the United States as an asylee for 10 years, but then returned to the home country. 7 years later, the person was admitted again on H-1B and now is filing through the spouse for adjustment of status. That's exactly the example they give you, that you had some previous history and then you're moving forward many years later, and they still can use that previous history against you. It means that most likely the processing times are going to be increasing significantly. because now they have to look through the whole entire file that you have. All right, so those are the negative factors. Now, what troubles me personally is the way they explain they're going to be using them, how they're going to be estimating which factor is going to weight heavily. They say that they're going to collect all the factors. The good news is that the negative factors is not the only factors that are out there. There are positive factors as well. For example, if a person knows English or studying English, if the person is pursuing degree, I will have a separate video on the positive factors. But I wanted to just finish up with 2 examples that they posted about how they're going to be estimating in a case which factors are going to outweigh which factors. So they posted several examples, and one example is an example of a child, a 5-year-old child, being sponsored by uncle. It means that uncle is really sponsoring the child's parent, and the child is together with the parent in that sponsorship, right? So this stated example, they said the child is 5 years old. He or she is going to kindergarten and is learning English. The household size income is above the poverty guidelines. The child has not been using public benefits. The child has a private health insurance and has not been receiving any subsidies through the Affordable Care Act. That's interesting. And uncle gave affidavit of support, and uncle has a huge income. So they stated that the child will be able to become a green card holder, but in the analysis they first mentioned that, well, the child does not have employment history in the United States. He doesn't. He's 5, or she's 5. They say, well, but the child is learning English, which is good. And then they talk about the private health insurance and the household income size. And they say that positive factors now are weight more than negative factors. And then there is a second example where basically, as I recall, a single son is sponsoring his single father who is a widower. The father has a heavy medical condition, one of those that they do not like, and the father doesn't have health insurance. The son's household income size is above the threshold, and they stated, and the father is 68 years old, and they stated that the father's family size is a positive factor. And I was like, wait a second, oh, that he's a widower is a positive factor. But in the end of the analysis, they're stating that the father is not going to be eligible, primarily because of the problem with the health and lack of health insurance. All right, so that's how it goes. But the father also didn't have education and could not show that he's going to be employable in the United States. Why I'm mentioning children and parents is because it's probably the group that's most vulnerable, because of course the child is going to be someone's dependent, understandably, so maybe the parent. And parents unfortunately tend to develop health issues just because of the age. So those are the factors, those are the examples that we need to pay attention to. It means also that if you will be filing for adjustment of status now, you have to be prepared very, very well. And again, remember that now it's going to be much more difficult to get an approval, unfortunately. Thank you for watching.